Thanks for joining us for today's episode of the Rock Island Wealth Management Spotlight. I'm Mitch Stoba, President of Rock Island Wealth Management. Today our spotlight's on Scott Husaby, partner at Monroe, Moxis & Berg. Scott, tell us a little bit about yourself and Monroe, Moxis & Berg.
Thanks, Mitch. My name is Scott Husaby. I'm an attorney and I practice primarily in the areas of estate planning and succession planning. I work with business owners and other moderate to high net worth individuals in their planning needs in those areas. I've been practicing for about 30 years, the last 20 at Monroe, Moxis & Berg. We are a 25 lawyer law firm located in Bloomington. We offer legal services to businesses, business owners, and other individuals with planning needs.
Awesome. Say, Scott, we do a lot of financial plans out there for clients and business owners, and we start talking about estate planning. What's the primary difference out there between like a will-based and a revocable trust-based estate plan?
That's a great question. The primary difference is when I sit down with estate planning clients, I try to focus them on 4 different planning areas: estate tax planning, personal succession planning, incapacity planning, and probate avoidance. With a will-based plan, we can address the first 2 issues, but we need a revocable trust-based plan if we want to try to plan for incapacity or probate avoidance.
Scott, in addition to will and revocable trust planning, what are some other important documents that should be in somebody's estate plan?
Sure. In part, Mitch, that depends on the type of plan, but there are certain documents that really should be in any good estate plan. I'd start with a durable power of attorney form. That's a document that gives a trusted individual the ability to make certain financial decisions and execute certain documents on your behalf. Then we move into the healthcare area. We start with a healthcare directive, which gives you an opportunity to name your healthcare agent, someone who's going to make your medical decisions if you can't. It also gives you an opportunity to express your wishes in certain situations, especially terminal condition situations. We like to supplement that directive with a healthcare instruction form, which lets you drill a little deeper on some other health issues, things like pain management. The goal is we want to put our healthcare agents in a position where they're carrying out your wishes rather than trying to guess what you wanted. And then the final part that I'd mention is the HIPAA authorization. HIPAA is think of it as the Medical Privacy Act, and we want to make sure our healthcare agents have access to all of our information if they have to make those decisions.
Those are great documents to have in a plan. Scott, you've been doing estate planning for over 30 years. What are some interesting concepts and strategies that people should consider going forward?
A couple of trends that I've seen in this area that people should think about is when I started estate planning, the estate tax exemption, the federal exemption, was around $600,000. Most of my clients at that time felt the need to address that potential issue given the size of their estate and that relatively low exemption. Over time, that exemption has increased to the current $11 million exemption that came out of the Tax Act last December. So now a couple can really pass up to $22 million free of federal estate tax. So most of my clients now come in wanting to think of other issues. And I would say the most popular issue is probably asset protection planning, especially as it relates to leaving assets to a spouse, children, grandchildren. They're also doing more charitable planning and trying to find ways to pass along family values, family legacy to the next generation. Another trend that I would identify is incapacity planning. It seems as medical science and healthcare keeps us alive longer, more and more of us are outliving our capacity. I'm having more and more clients call with capacity issues, and if it's not planned for, it's a pretty painful process.
Scott, you just mentioned asset protection. Can you give us a couple examples how you incorporate asset protection in a properly drafted estate plan?
Sure. The first example I'd give you is when I'm dealing with couples. Most of the couples I deal with tell me that at the first death they'd like the survivor to have full access, full control of the funds. The problem is if we don't do some planning with that, we're really leaving those assets up to the mercy of the survivor's estate plan. Let me give you an example. Let's assume I predecease my wife and she remarries. The assets that she and I have accumulated over 30 years now are going into a new marriage, and depending on their estate plan, if they have one, or even state law, which is going to give husband number 2 some rights in those assets, there's a scenario where none of those assets end up back to our children.
Sure.
So we do a lot of marital trust planning that gives the survivor control, access, but it gives a couple an opportunity to sit down today and say, where do we want those assets to ultimately go once we're both gone? Another example that I spend a lot of time on is asset protection planning as we're looking at passing assets to the next generations. A lot of estate plans that I review involve distributing assets to children at ages between 20 and 30, or if the children are adults, even outright distributions. And my view is those are the formative years where children are, likely finishing their education, possibly buying a house, getting married, getting into a business. And if there's a misstep in any of those areas, all of those assets are at risk. So I'm a proponent of what I call perpetual trusts, where we leave the assets in trust, and at certain ages bring the children into control of those assets, but try to mentor them so that they take assets out when they need them. Otherwise, view the trust as an investment vehicle, which is protected from creditors, divorcing spouses, personal guarantees.
That's a great point, Scott. Talking about ownership and titling, how important is it for an individual or couple to review their ownership and titling in their estate plan?
Yeah, it's extremely important, Mitch. This is an area that you and I work with clients on a lot together. You can have a great estate plan, but if you don't follow that up with the proper titling and beneficiary designations on assets, the plan itself can be frustrated. So, for example, if we're looking at a revocable trust-based plan, we want to title as many assets as possible into the revocable trust. That avoids probate, gives us control in the event of incapacity, and the privacy that comes with avoiding probate. A lot of my clients will have assets owned in, say, joint tenancy with rights of survivorship, or they might have a pay-on-death designation. They need to know that titling is going to avoid or possibly frustrate the estate plan. We also want to look at life insurance, IRAs, other qualified plan assets, and make sure the beneficiary designations are coordinated so that we have an overall plan that at the end of the day carries out what the client wants.
Scott, the last question I have is I've heard a lot of clients, in fact, a current client just asked me about changing the residency from the state of Minnesota to another state to avoid the income and estate taxes. What are some things that a client should consider if they're going to make that choice?
Yeah, that is becoming a popular issue in Minnesota. Minnesota is among the worst states, both from an income and estate tax standpoint. In the past, it used to be a simple test. If I was outside of Minnesota at least half of the year, more than 183 days, I could take a position that I was no longer a Minnesota resident. Minnesota has cracked down on that, and they still have the 183-day rule, but they've also added an intent factor. So in addition to being out of Minnesota, I also have to demonstrate an intent to become a permanent resident of another state. Minnesota publishes a list of factors. There's about 25. They range from where's your driver's license, where your vehicle's titled, where you're registered to vote, where have you claimed homestead tax status, and it goes on. And no one factor is controlling. It's kind of a totality of the circumstances, but our clients should try to check off as many of those factors as they can if they're trying to move to another state for tax purposes.
Scott, thanks for taking your time to be on today's Spotlight and sharing your time and expertise. I know you've helped out many of our clients with their estate planning needs. Please feel free to reach out to Scott and Monroe Moxelson-Berg, and also that checklist that he has available. I'm Mitch Stoba with Rock Island Wealth Management. Please feel free to contact us, and as always, have a great day and keep smiling.